Hello, and welcome to another podcast. I'm Colin Beaumont. I'm retired now. I did spend more than 30 years in practice in one form or another, mostly police stations, magistrates' courts, prisons, that sort of thing. Clive.
Welcome back, everybody, to our regular listeners. This is the next episode in our series of shows. My name's Clive Smith. I'm a barrister. If I was a prisoner, Colin, they described me as half in, half out. I did 11 years in practice, and I've done about a similar time out of practice now. Although, whilst I'm out of practice, very much still try and keep up to date with the law. And I have to say, Colin, if I was still in practice, I have no idea how I'd keep up with everything going on, because right now it's a full-time job keeping up with everything going on outside court with the Leveson review, which I'm going to talk about. Review into sexual offences and various other things as well going on. So busy time as ever, never a quiet time. And of course, the sentencing review. Never a dull day in criminal law, is there, Colin?
Certainly not. And of course, that's why the podcast is so useful, because we have the time, do we not? And we're quite happy to wade through these documents, and then hopefully we give you the distilled essence of it all. Hopefully. You judge for yourselves. We're going to kick off with then, Clive.
Well, we thought, as our last podcast was about Leveson, we thought we may as well kick off there and talk about what the plans are for change, and then really talk about where we are now. So, as you know, Colin, the Leveson review, Sir Brian Leveson, has recommended a change in relation to the amount of credit that defendants should get if they plead guilty. And as you know, Section 73 of the Sentencing Code talks about credit for a guilty plea, and the maximum credit you can get for a guilty plea is 1/3. But Sir Brian Leveson is suggesting that should go up to 40%. I know you're very keen on 50%, Colin, because the maths are easier.
Well, I am. Let me make a serious point there for a moment. I think that if you're going to tinker with it, why not make it 50%? It just makes it that much easier. I don't wish to be disparaging at all about, the average client. Crikey, you and I both know maths is not my strong suit at all. But it's much easier to talk in terms of 50% or half, rather than the 40% or 2/5. I mean, there is a reason why in the sales, all the posters say 50% off, or half price. So It's just me. I just think it would be that much easier to have a conversation with the client if you can tell him or her that a timely early guilty plea would result in a half of the sentence they would otherwise receive. That's it. I've had my say.
And if they go to trial, they get twice as long. I suppose that's the other way of looking at it too, isn't it?
No one has asked me to do a review. I'll let you to a secret. They never will.
Very good. So that's where we're potentially going, isn't it, Colin? But where are we now? We've mentioned Section 73 already, haven't we, of the Sentencing Code? I think importantly, the law and indeed the guidelines, the Sentencing Council, June 2017, guideline on reduction in sentence for a guilty plea, talks about when a defendant first indicates their willingness to plead guilty. And I think if you can get that under your belt as a lawyer, if you can understand that, then I think a lot of this follows on quite logically. Because yes, there is a time when someone pleads guilty, but equally there is a time when they can indicate their willingness to plead guilty. You can indicate your willingness to plead guilty to the police officer when he arrests you. It's a fair cop, gov. Yeah. You can go into interview and you can make full admissions in interview. Of course, you can't plead guilty to the police officer or plead guilty in interview. But all these things are important, aren't they, Colin?
They are important, but having said that, of course, is there any benefit to a suspect, as it were, making admissions to a police constable or making admissions in relation to the interview? Because as we know, this concept of credit is a legal concept that applies only at the stage in the proceedings at court at which you indicate your willingness to plead guilty.
And in all of this, I think the other point to bear in mind is what the guideline says from the Sentencing Council about the reasons, the benefits of a guilty plea. In some countries like Japan, for example, they hold the guilty plea in really high regard. Something like 60 or 70% of people plead guilty in Japan. They want you to be convicted by your own word, effectively. So there's no doubt about the fact you've pleaded guilty, you admitted it, and therefore you must have done it. because of all the people in the world who knows whether you've done it, you're the one. And so I suppose there's always that aspect, isn't there? There's always that degree of certainty when someone's pleaded guilty, which is never to be diminished or undermined. But equally, of course, it avoids witnesses having to come to court and give evidence. It avoids them having to go through even the process of worrying about having to come to court. If you plead guilty on the first day of trial, they've still had to worry for months at the moment, years, that they've one day have got to come to court and give evidence. But if you plead guilty at an early opportunity, then they will know that they will never have to give evidence, which is always reassuring. Then, of course, there's the time and money saved in terms of the investigation, in terms of the police saying, right, well, he's admitted this in interview. Once we go out of interview, we can charge him, take him to court, and effectively I'll just have to dot the I's and cross the T's and make sure the statements are all sorted to get into court. But I don't really need to go and do any further investigation or work as a general rule, do I? So there are various advantages, aren't there, that the guideline sets out as to why it is important or why it sort of benefits, great benefit if people do plead guilty.
Yes, and those are important considerations. Admittedly, might be sometimes difficult for victims to sort of get their heads around. Why should this person have any credit whatsoever? You know, what they've done the particular crime. Why should they feel the full force of the law? Can I mention at this point, Clive, there are show notes to go with this particular presentation. They're quite fulsome in the sense that we've given you the whole of the Leveson review, so you can have a look at that. We've also given you the document published by the Sentencing Council. It's an important document, isn't it? Reduction in sentence for a guilty plea. That's been with us, hasn't it now, since the 1st of June 2017. 1st of June 2017, available on the Sentencing Council website. Clive, can I just mention a couple of things in relation to this 1/3 if you enter or indicate a timely guilty plea? Because that's not always the case, is it? For example, in relation to those offences where the court is obliged to consider the imposition of a mandatory sentence. I'm not saying they're going to, but we know, don't there? There are several situations in which a court has to consider at least the imposition of a minimum sentence. And of course, if the minimum sentence is imposed, then the credit is by way of 20%. Yet the sentence shall not fall below 80% of the minimum sentence. So you're capped effectively at 20%. That's set out for you in section 73. That capping, incidentally, only applies to adults 18 or over. No applicability for youths 17 or below, where the court can give whatever credit it wants to. The other thing I want to point out, if I may, reduction in sentence for a guilty plea, where the client is before the court for a multiplicity of summary-only offences. It might be driving whilst disqualified on a number of occasions. It could be driving whilst disqualified, common assault, public order, section 4. These offences, of course, because they're summary-only, don't matter how many you have, the court is capped at a maximum sentence of 26 weeks, 6 months. And of course, if you enter timely guilty pleas, the document doesn't speak in terms of 1/3. It says that there may be some modest reduction to reflect the timely guilty pleas. Modest. Oh dear, how modest is modest? Well, it's not 26 weeks, says the district judge. It's 24 weeks. Ouch. So just be aware of that.
It's M&M, Colin, to the extent it's modest and may, not must. So the district judge could say, no, thank you. You've got 6 driving whilst disqualified. 6 months, off you go.
But that seems to me to be somewhat bizarre because it's a nod. It's a nod towards the court thinking, well, you're lucky. The maximum is 6 months anyway. But that's for Parliament to decide. It's not the defendant's fault that the court is capped at 26 weeks.
Let me make 2 points, Colin, because I'm conscious that we dive straight in because we're guilty of that at times because we're used to dealing with all this. And we may have some people tuning in, hopefully we do, who are not lawyers. And so I think an important point is the starting point when it comes to credit. We've already mentioned that if you plead guilty at the first available opportunity, at the first appearance, for example, in a magistrate's court, or if it's what we call an indictable only offence, or something like rape or robbery, those sorts of things, then you have to indicate your guilty plea in the magistrate's court because you can't actually enter it there. Then you'd be entitled to a third off. If you enter a guilty plea sometime shortly after that, so well in advance of trial, then you're going to be looking at credit in the region of around 25%, aren't you, Colin? And then if you wait until the day of trial, if you drag things out, you wait until the day of trial and say, oh, well, all the witnesses have turned up, the writing's on the wall, I suppose I've had to plead guilty now, then you're looking at credit of somewhere around 10%. So it's very broad figures. We start off at 33%, somewhere in the middle at 25%, and then at the end, 10%. And the second point, if I may, you make a good point about credit when it comes to minimum sentencing, Colin. Sadly, as you just pointed out, that there's no consistency at times. And it depends what offence the minimum sentence is attracting, to the extent that if it's a firearm, then, as you know, Colin, you can't go under 5 years, can you? So a minimum term of 5 years as a sentence for a firearm, you cannot go under 5 years, even following a guilty plea if the defendant is 18, 19, 20 or above, for example. And you make the point, and I think a good example is the offence of burglary, a 3 strikes burglar. So someone who's up for their third dwelling burglary, as you say, you may get up to 20% credit. So you can't, says the law, go below 80% of 3 years. So if a client were to say to me, Clive, will I still get my third off for in terms of my sentence for my third strike burglary? I'm going to give them that classic lawyer's answer, Colin, because the answer is, it depends. And as I said to several clients on more than one occasion, when they said, well, so am I going to get the minimum 3 years? I said, no. I said, that's the minimum. I said, the judge could go well above that because this was a particularly nasty burglary. And let's pretend he does go well above that, or she goes well above it and takes a starting point of 6 years imprisonment. Okay, 6 years imprisonment for your third burglary, or it might even be your fourth or fifth, who knows? But let's pretend it's your third. And she says, starting point of 6 years imprisonment. Clive, am I going to get a third off? Yes, you are, because the judge can sentence you to 4 years and give you your full third off. And we know, don't we, Colin, that 4 years is more than 3 years, and 3 years is the minimum term. However, if the starting point is 3 years, as you say, Colin, then the judge cannot give you the full third off, because to do so would be against the law. It would go below the 80% of 3 years. Somewhere in the region of about 28 months imprisonment, isn't it? 28 months imprisonment, give or take, is about 80%. So that's the minimum. That's the minimum you could get for a 3-strike burglary where you've indicated your willingness to plead guilty at the earliest opportunity. But, as we say, with things like firearms, minimum firearms, ammunition, those sorts of things, you might be subject to 5 years and you can't get your third off because you can't go below 5 years, can you, when it comes to credit, Colin?
That's true. And I think the Court of Appeal has said that if you're dealing with the sort of 80% of a sentence, probably better to express the sentence in terms of days, because it's so much easier for everyone to calculate when you break it down into days rather than months and weeks. If you break it down to months and weeks, you might make a mathematical error, which you're not going to make if you do it in terms of days. So, calculators, the ready, please. Like Clive just mentioned, because it's a cracking case, isn't it? And it's the case of Plaku, Borden and Smith. It's in full as part of the show notes. And to be fair to the Court of Appeal, they didn't in any way make it unclear as to what the position should be. They spelt it out in very simple terms and said, look, if you can plead guilty in the magistrate's court, you must do so on the first occasion in order to be assured of your full 1/3. If you can't enter a plea because it's indictable only, you must give an unequivocal indication of guilt at the magistrate's court stage, followed by a guilty plea at the PTPH. Yeah, that assures you of your 1/3. Anything other than that, said the Court of Appeal, and it then becomes an issue for the Crown Court judge as to whether or not he or she, having heard submissions, decides that it's going to be something nearer 25% rather than 1/3. They couldn't have made it any plainer.
No. I have to say, Colin, in the I think Plaku, Borden, Smith, you say, is very clear. And the other benefit for the lawyers listening to this is if you want to know what the latest is on credit, go and read Plaku, because what it also does is it distills about 6 other judgments. So instead of reading 7 judgments, you can just read Plaku, can't you? And it says very briefly, this is what happened in this case, this is what happened in the other, and here's the current position. That's the other benefit of reading Plaku. But I have to say, I think there was some criticism from practitioners in the immediate aftermath of Plaku that it showed a bit of a disconnect, if I may say so, or if they may say so, between the Court of Appeal and life at the criminal bar, and certainly as a criminal solicitor as well. And I think there is a lack of representation of criminal lawyers in the Court of Appeal at the moment. And we know, don't we, Colin? You and I have both been in the magistrates' court. You might turn up for an undercover supply case, undercover drug supply case with a test purchase officer. Your client's got 12 counts of supplying Class A drugs against him. And your client says to you, well, I'll plead to 8. I'll plead to 8. You go off and see the prosecutor. And the prosecutor says, I can't take pleas today. I've got 17 defendants here. It was an undercover operation. They were all nicked yesterday. I've got 17 cases and I can't make decisions about whether I'm going to take pleas today. So, you go and speak to your client and say, look, if you want to plead guilty to all 12 today, you can, and you'll get your full third off. You'll be guaranteed when you get to the Court of Appeal to get that 1/3 off. Or it might be you want to keep your powder dry and you want to wait till you get to the Crown Court and you want to say to the prosecutor then, look, I'll plead guilty to these 8. Will you take a view on the other 4? And the prosecutor might do that. And doing the maths, it might be that getting 25% off your 8 counts results in a lower sentence than getting 1/3 off your 12 counts. I don't know. So it's a bit of a gamble at times, isn't it, Colin? And I think some people felt that Plaku doesn't really acknowledge the reality of life in the magistrates' court at times. However, in saying that, I hope, and I'm sure I hope that there are enough Crown Court judges out there who do remember what life in the magistrates' court was like, or doing these sorts of cases was, and they will have a little bit of sympathy. I certainly remember being in almost that situation. I became involved when the case got to the Crown Court, and there were about 20 defendants in a London Crown Court, and there were half a dozen police officers turned up with laptops, with all the undercover supply, CCTV, all the camera evidence, which they said, we're here all day, borrow our laptops, go and see your clients, take instructions. And the judge got us in at 10 o'clock that morning. He said, I don't care that you've all pleaded not guilty in the magistrates' court or not indicated a guilty plea. He said, if you plead guilty today, I'll give you a full 1/3. I'm here all day. Use the cells, use the officers' laptops, come back and let me know what you want to do. And everyone pleaded. And it was a very sensible way of dealing with it, I have to say. And that
Absolutely.
was an acknowledgement by the judge, and I'm sure the list officer was very happy with him that we weren't setting long trials for the future.
You see, I remember reading a case. I think I did a case summary about it. It struck a chord with me. It was a case where a client had been charged with a lot of quite serious offences. It was a question of being in custody and in court in the morning, and being dealt with by a very experienced solicitor. And the point was made in Court of Appeal that the police and the CPS had had months and months and months concerning this particular case. And yet, as it were, there was this need for the defendant to enter timely guilty pleas at the magistrate's court at the first listing in order to get the full credit. And the point made by the experienced solicitor was that was a wholly unrealistic expectation at that first listing in the magistrate's court. And furthermore, and this was another point made by the same experienced practitioner, he said, I was in this position. The client, upon entering guilty pleas, had he been advised to enter guilty pleas, would have been committed for sentence. Okay? Would have been committed for sentence. Now, the legal aid position is that if you're ineligible for legal aid in the magistrate's court, if you're using the duty solicitor, if you're ineligible for legal aid in the magistrate's court and you enter guilty pleas and you get committed for sentence, there is no legal aid at the Crown Court. You can't even apply. You're only eligible to apply for legal aid if you withhold your pleas and you get sent to the Crown Court and you enter your pleas on indictment. In those circumstances, you're entitled to legal aid with or without a contribution. So, pity the poor person who's got a job and is therefore ineligible for legal aid at the magistrates' court stage, entering guilty pleas, being committed for sentence on serious offences, and you can't even apply for legal aid for the Crown Court hearing, which, of course, is going to be a serious hearing, is it not? Because you've been committed for sentence, the magistrate's taking the view there's a serious offences and their sentencing powers are inadequate. Now, you're a working man or a working woman, but you still haven't got the wherewithal to pay for counsel to represent you at the Crown Court hearing. I just think that needs to be addressed. If you're going to encourage timely guilty pleas, you've got to address that issue. And of course, when this experienced solicitor via counsel argued these points in the Court of Appeal, the complexity of the matters at the magistrates' court stage and the lack of legal aid in the event of pleading guilty and being committed for sentence, the Court of Appeal said, well, these are not really matters for our concern. And I thought, well, with respect, those are hugely important matters when you're at the coalface.
Yeah, as you show, it shows a bit of a disconnect at times, doesn't it, Colin, in terms of the reality and the theory. So, and that was some of the criticism. Before we leave that, though, can I mention the case of Hodgin? I love the case of Hodgin.
You always mention Hodgin.
I know, as I said, it's one of my favourites. I don't know who the judge was. I'd like to buy him a drink. I always remember Mr. Hodgin because Mr. Hodgin was hedging his bets. That's the easy way to remember the name of the case. Mr. Hodgin was hedging his bets. And he said in a magistrate's court, didn't he? He said, likely to plead guilty in the Crown Court. And that was what was put on the form, on the better case management form. And that form then went to the Crown Court. He pleaded guilty and the Crown Court judge gave him 25%. And he said, well, that's not fair. He said, I indicated in the magistrate's court that I was going to plead guilty. And the Crown Court judge said, likely to plead guilty means nothing and is well known to mean nothing. Now, there's a judge who's been round the block once or twice. And the Court of Appeal said, we agree and we support the Crown Court judge.
Oh, dear. What? And they say there's no place for humour in criminal law. Don't you believe it?
And I can imagine the grin on his face as he said it as well. Shoot it with me. But yeah. But I thought, there are plenty of judges out there that I can imagine saying that to me as well. Come on, Mr. Smith. Likely to plead guilty means nothing and is well known to mean nothing around here.
Right. It's just a great expression, isn't it?
It is. But the point is, Colin, for those people listening in, when you're in a magistrate's court, because people think, well, this is going to the Crown Court. I'm a solicitor. I don't really deal with it there. But what you do in the magistrate's court is going to have a huge knock-on impact in the Crown Court. When I teach and train legal advisors, I say to them, look, you need to be pulling the defence solicitor up on this. If they've put on the better case management form, likely to plead guilty, you need to be saying to them, have you read the case of Hodgin? Go away and read it because your client's not getting full credit. And they will not thank you. It's important, really important. This podcast is recorded on behalf of Legal Eagle Training. You can find us at legal-eagle-training.com.
Legal Eagle Training has nearly 100 one-hour recordings already on the website, and most of which come complete with notes. We've been doing these now since June 2020 on topics as diverse as
the Magistrates' Court, including the Youth Court,
life at the police station,
road traffic,
advocacy, Magistrates' Court advocacy, Crown Court advocacy,
criminal law updates, including case law and the latest legislation,
and the subject we both know most dear to your hearts, the billing of criminal legal aid.
The website is constantly being updated with new courses on the latest topics. We add 2 further presentations on the website per month. Each presentation lasts an hour and comes with a full set of notes. Do visit the website, as there's going to be something there that appeals to you as someone involved in criminal law.
Right, back to the episode. Having canvassed somewhat the difficulties of the poor solicitor at that first appearance in the magistrate's court, let's just consider for a moment the position at the police station stage. Because, of course, we have that very important case, don't we? In full, again, in your notes. And it's the case of Caley and others. Yeah? Court of Appeal, December 2012. In which the Lord Chief Justice really considered the point of someone who didn't go no comment in the interview, but rather made full admissions, was fully cooperative, and showed remorse. Now, how are we to approach this particular person in the sentencing exercise? Was the question posed by the Lord Chief. And the Lord Chief said, look, I think it's important for everyone to appreciate from the outset that we're not here concerned with credit, because credit, of course, is a legal term, only kicks in at the point at which you plead or indicate your willingness to plead guilty in court proceedings. So, is the person who makes admissions, shows remorse, is cooperative, is that person to be treated as on a par with a person who went no comment in the sentencing process? Well, not necessarily, said the Lord Chief, because the court could reflect that those early admissions, cooperation and remorse, and here's the expression, by starting the sentence at a lower starting point than it otherwise would have done. Starting the sentence at a lower starting point than it otherwise would have done, and from that lower starting point, of course, deducting whatever credit is coming the client's way. Now, Clive will tell you, I'm not very good at maths, but even I know that if you deduct a third from a lower starting point, you end up with a lower sentence. Now, the difficulty is that when you're talking to clients at the police station stage, you're juggling a probability or a possibility with a certainty. What's the certainty? The certainty is if you make full admissions, you're going down. The possibility is you might go down for a lesser period if you fall on your sword in the interview today. Well, I'm not advising you to fall on your sword because, as the Lord Chief said, it's a case-by-case judgment call for the judge as to whether or not he or she wants to start the sentence at a lower starting point than he or she otherwise would have done.
And there are other reasons, aren't there, said the Lord Chief and the Sentencing Council guideline, as to why the judge might start the sentence at a lower point. It might be, for example, the defendant's handed himself in. That might be something you want to raise and say, look, he's handed himself in. He didn't make the police go and find him. And if you look at all those reasons as to why credit is important, that's one, isn't it? He saved some time and money and effort, hasn't he? It might be he's taken suspicion away from others. It might be, 3 young lads are arrested in a car with some Class A drugs under the driver's seat. They arrest all of them. They're about to charge all of them. And one of them says, do you know what? Actually, they're mine. And the other 2 knew nothing about them. Makes the prosecution's job very difficult to try and charge all 3, doesn't it? A bird in the hand is worth 2 in the bush. And I think they take the admission from one and drop it against the other 2, depending on the circumstances, of course.
And is there not an arguable case for saying in all cases, really, the sexual nature, if he or she makes full admissions in their interview, is there not something to be said for the fact that the police officer in the case will at least be able to have a word with the complainant stroke victims and say, look, I can't guarantee anything. There are no guarantees in life. But in all probability, you won't have to testify. There won't have to be a trial because he's made admissions in a police station interview.
It's a huge benefit, isn't it, in such cases?
It's a consideration, isn't it?
Yeah.
And yet, again, I don't wish to be disrespectful, but I know that there are lawyers who are watching this podcast who are saying to themselves, yes, Colin, and you try getting that point home in the magistrate's court.
Do you know what, Colin? The point that I often hear, so when I'm teaching and training and I raise this, and they say to me, well, I've never seen that happen in court. And I always ask them the question, I said, well, how many times have you ever seen people argue it? And they say, never. And I said, well, the sentencing court is not going to do your job for you, as an advocate, either prosecutor, but usually defence counsel in cases such as this. The court's not going to do your job for you. If you're not raising these arguments, then why should they take them into account? Yes, they are a little bit niche. Yes, they're a little bit unusual. But this is what separates the good advocates from the great advocates, isn't it?
Yeah, absolutely. Absolutely. And I think you can put it on the basis of, look, bearing in mind how cooperative he was in the interview, are you really, in your sentencing exercise today, are you really going to put him on a par with the person who simply goes into an interview and goes, no comment? Yeah, with respect, that defies all logic and sense.
And you might have co-defendants. You might have two co-defendants. One's gone into interview and got no comment. The other's gone into interview and made full admissions. And I remember teaching and giving this example once, and I said, what should happen there? And I said, arguably, the one who made admissions, if they're perhaps got no previous convictions, very similar, personal mitigation, all those sorts of things, there's nothing to distinguish the two of them. The one who made admissions in interview should get a lower sentence than the other one. And some bright spark piped up and he said, yeah, Clive, he said, but you know what happened, don't you? He said the one who'd made admissions would be charged and the one who went no comment, they'd NFA them.
There's more than a grain of truth in that. I think we're waiting
quite.
for a decent court of appeal judgment, just setting this all out and saying, yes, the judge was absolutely right to treat these two defendants differently in the sentencing process for these reasons. Or, and here's something radical, I can tell you now, no one's asked me to conduct a review of the criminal justice process, and they never will. But here's something radical. How about saying, well, it's 50% then, if you fall on your sword in the police station?
We're about to get a new vice president of the Court of Appeal Criminal Division, Colin. It's going to be Lord Justice Edis. He's taken over from Lord Justice Holroyd. So he's a very wise and experienced criminal practitioner. So if anyone was going to give that judgment, it may well be him. So perhaps we'll be recording this podcast in a year's time and saying, there we are, told you so.
I'll just say this as a serious point. If you're going to want to encourage suspects at the police station to make admissions, you've got to give the suspect and the legal advisor at the police station something meaningful to work with.
Good. What else would you like to talk about, Colin?
Well, can I talk for a moment about money? In relation to encouraging guilty pleas? Because it does say in the Leveson review, doesn't it? And I'm quoting from paragraph 137. You have the review in full as part of these show notes. At paragraph 136, Sir Brian Leveson talks about Sir Christopher Bellamy's report, highlighting the Criminal Law Solicitors Association argument that the fixed rate paid to litigators for committals for sentence from the Magistrates' Court to the Crown Court is lower than the basic fees applicable in the Crown Court in many cases, even for a guilty plea in the Crown Court. In other words, that might lead to a perverse incentive whereby, as it were, it's more remunerative for the client to hold off the plea until the first hearing at the Crown Court, rather than entering a timely guilty plea and being committed for sentence. Let me just read you paragraph 137. I agree with Sir Christopher's assessment. This disparity, and I'm not sure this is necessarily true, I'm just reading a paragraph from the review. This disparity in fees between the fees applicable at the first listing on a guilty plea or a guilty plea and a committal for sentence, this disparity in fees is creating a perverse incentive whereby solicitors are likely to be paid more by the defendant not pleading guilty at the first hearing, but instead proceeding to the Crown Court before pleading. The solicitor would thereby obtain the Crown Court fee for a sentencing hearing rather than the plea for a guilty plea and sentence in the Magistrates' Court, or potentially the fee for committal for sentence. Removing this perverse incentive would, in my opinion, reduce the number of cases cracking. So there you are. I think what they're saying is, look, it might not be happening, but let's just ensure that, as it were, it isn't the consideration of the fees that's in any way affecting whether or not clients enter timely guilty pleas. I just give it you because it's in the report.
What else would you like to talk about, Colin?
Well, I'd like to talk about those cases in which the Court of Appeal have had to wrestle with whether or not the Crown Court judge was right to give 25% rather than a third. Because we know, don't we, that a lot of these cases end up at the Court of Appeal. If the sole argument being, surely it should have been a third judge rather than 25%. And we've had a number of cases in which the argument has been, well, look, there was some issue as to whether or not this person was even fit to plead at the magistrates' court stage, and we had to get a report. And once we got that report indicating that he or she was indeed fit to plead, at that stage, they were so advised and they entered a guilty plea. Is that a timely guilty plea? Yes, said the Court of Appeal. And they've said it more than once. So long as you're not playing games, so long as you're not trying to play the system, if a guilty plea is entered after a report has been considered whereby the client is fit to plead, if at that stage there is a plea, then that should be considered to be a timely guilty plea. Common sense, really. What else can you do as the poor solicitor at the coal face? He's not fit to plead unless we've got a report indicating he's fit to plead. Crikey. I've got, as a solicitor, you've got people like the SRA to worry about when you're advising clients.
The difference there is 8%, isn't it, from 33 to 25? Arguably, the bigger issue happens when the defendant says, for example, at the Crown Court, the first appearance in the Crown Court is plea and trial preparation hearing, I'll plead guilty to this. And the prosecution say, no, we won't accept that. Yeah. And then on the day of trial, the evidence has changed or one of the witnesses hasn't turned up and they say, oh, actually, we will accept that now. Now, of course, if you plead guilty on the day of trial, strictly speaking, you should get 10%. However, if you indicated your willingness to plead guilty to that offence at the PTBH, that's a 25% credit case instead of a 10%. And I had exactly this argument once at Southwark Crown Court. I took the judge to the guidelines and I said, and the judge said, well, no, he's only pleaded guilty on the day. It's 10%. And I said, well, the guidelines say that it's when he first indicated his willingness. And he said, do they? And I took them to him. He said, Mr. Smith, you're right. He said, and I will give your client 25% instead of 10%. Now, Colin, that was the difference between my client going to prison or not. Because it was a massive chunk of credit, that was the difference between him going inside or not.
Wow.
So the point that we're making is that even if you don't enter a plea, it's important that you indicate, particularly in the Crown Courts, that you indicate your willingness, because of course we don't have alternatives in the mags, do we? But you must indicate your willingness in the Crown Court to plead guilty. I think it's a box on the form now, on the PTPH form anyway, that are there any alternatives that you consider pleading guilty to? And I think that box has never been more important in today's day and age because, as I say, 15% credit, the difference is huge and can have a huge consequence in terms of it potentially being the difference between going inside or not.
Again, dealing with that poor solicitor counsel at the first listing in the magistrates' court, you've really got to be alert and on the ball because the client may not have even faced that particular charge at the magistrates' court stage. And yet, all of a sudden, on the indictment, there's the count on the indictment. He enters a guilty plea, and you think, oh, well, that's the first opportunity he's had to enter a plea to that particular count. That must be a full third. And the judge says, well, no, it's 25%. He could have, albeit he hadn't been charged at that early stage in the magistrates' court, he could have indicated to the prosecution at that early stage that if they were to bring forward such a charge, he would plead guilty to it.
Yeah, I think there was a burglary case like that, wasn't there, Colin, in the Court of Appeal, where he was charged with aggravated burglary.
That's right. It's the case of Regina and Morrow, when it's in your case notes, Regina and Morrow. Yes.
Could have indicated that in the max, couldn't he, that you plead guilty to simple burglary?
Yes. And I think, again, there's something on the form, isn't there? Are there any matters to which you would be prepared to indicate a plea at this stage, albeit you haven't been charged with them? So that's almost a nudge or a reminder. Do give a thought to matters with which he or she has not even yet been charged.
Yeah. Anything you'd like to tell us?
Yeah. Going back to Caley, of course. This is particularly relevant, I would have thought, when you're at the Crown Court and you're seeking to persuade the judge. You always want the lowest category, don't you? You want Cat 3 as the starting point rather than Cat 2. You want Cat 2 rather than Cat 1. I think it does say somewhere in that document, a reduction in sentence for a guilty plea published by the Sentencing Council. You've got the document in full in your show notes, that a judge can take everything into account, of course, in determining the category, including the client's admissions cooperation at the plea station stage. So that's something to throw into the mix when you're addressing the Crown Court judge as to which category this case should fall into. You and I both know that in terms of the sentence, there are two really important stages in the sentencing process. Firstly, how am I going to categorize this? 1, 2, or 3? And secondly, what sentence am I going to choose between the various range of sentences available now that I've plumped for a particular category?
Now, Colin, I was going to ask you, what happens if you're caught red-handed? Can the judge withhold credit from you?
Well, once upon a time, yes, in the sense of your credit could be reduced, couldn't it, if you were caught red-handed? It was a case of Regina and Joy. Let me tell you, there was little joy in the case of Joy. But of course, that went, didn't it? That went when we had the document reduction in sentence for a guilty plea, where the Sentencing Council have said, regardless of the evidence, even if the evidence is overwhelming, you're still entitled to your full 1/3, which is clearly something that some Crown Court judges simply don't agree with, because they won't give the full 1/3, and the matter has to go to the Court of Appeal. I've read more than one of those.
But it's easy, Colin. You just increase the starting point a little bit without telling them. That's the way round it.
No.
Hey, if I may offer an opinion.
You'll never get a judicial appointment if you come up with views like that, Clive.
I'm sure there are judges out as the right. I'll just nudge the starting point up a little bit, and then a third off instead of 25% off will get us to the same figure. So.
You're allowed to say those things when you're 68. You're not allowed to say those things when you're 40.
Are you saying I'm very cynical for one so young, Colin?
Dear, oh dear. My brilliant future is well behind this business of changing your plea. Oh dear. During the currency of the trial. Crikey. Hey, it's never a good thing, isn't it? Is it? He or she has been holding off, and the complainant has now given evidence for 2 days, and he's thinking, crikey, I'm up the creek without a paddle here. I'm going to have a meaningful chat with my brief about changing my plea.
Sometimes the indication comes from the bench, Colin. I remember doing a multi-handed public order case. And at the end of the first week, we were scheduled for 2 weeks. The prosecution closed their case on Friday afternoon. And the judge said, and it was one of those, we were waiting to see if they all turned up and what they said when they did turn up. And they did turn up, and they did say what the prosecution wanted them to. And the judge very gently said at the end on Friday, he said, you're about to give evidence, I assume. He said, but I can say now that if you were to enter guilty pleas, then I can't think that an immediate sentence of imprisonment would be necessary. Would you like to take instructions? Come back Monday morning and have a think, he said. We all went back and pleaded on Monday morning. So. But equally, there was a judge. I was doing some training a few years ago now, advocacy and the vulnerable training, and one of the judges doing the training there, she said something very nice. She said, there is always credit to be had in my court. There is always credit to be had in my court. And you can see in that example, I'm giving an anecdote, but equally, we've just saved 5 days of court time. That should not be sniffed at. We were pleaded and done and adjourned by 11 o'clock. That meant he could take another trial for the week. No, that's not to be sniffed at. If you plead guilty and save the court a few hours, so be it. But where we all pleaded guilty and saved them a week's time, then you might want to argue there's a bit more than 10% to go round, mightn't? But yeah, she said there's always credit to be had in my court. I thought that was a nice thing to hear from the bench.
Yes, I agree. In terms of changing your plea, never very attractive, but in terms of changing your plea once the trial has started, I think there's a lot to be said for the judge saying, well, what are the benefits? What benefits have been achieved? In other words, have people who would have found the giving of evidence somewhat of an ordeal, have they been spared that ordeal by this change of plea? And the more vulnerable those people are, And the younger those people are, the more there should be some credit. And who knows, it might even be as much as 9 or 8%. Of course, if by changing your plea, as it were, obviating the need for police officers to testify, well, that's just a completely different consideration. And it might be as little as nothing at all.
But yeah, equally, if it's if the officer was assaulted, for example, in it, then it may be a bit of an ordeal for them to give evidence in what's actually become a little bit personal for them. So,
Clive, can I throw a question at you? What have the court said about the stage? At what stage? What is the stage of the thinking of the sentencing process whereby you deduct whatever needs to be deducted by way of credit? Is that the very last thing you do?
I think it is, isn't it?
I think it is, isn't it?
Yeah,
I think it's the very last thing you do.
Yeah.
Otherwise, mathematically, it can get a bit confusing, can't it? Especially when you're dealing with youths.
Yes.
Because we have that document, don't we, published by the Sentencing Council. I think it was the 1st of June, 2017. Overarching principles, the sentencing of children and young people, guidance essentially to judges when they're sentencing youths as to quantum in terms of sentence. The guidance saying something like, if you're dealing with someone 17, 16 or 15, you might want to take a sentence broadly in the region of 50% to 2/3 of the sentence that would have been available for an adult. If you're dealing with someone below 15, gosh, might even be a sentence less than half of that which would have been given to an adult. So do all of that first of all, yeah, and only when you've arrived at the appropriate amount should you then deduct whatever credit is coming the client's way. Otherwise, you end up mathematically giving this youth a higher sentence than he or she would have received. I think there have been a couple of cases in the Court of Appeal where they've had to get their calculators out and say, no, the maths were wrong because the credit factor was done too early.
Yeah, you're right. To that point, Colin, we were talking about cases getting to the Court of Appeal, and advocates shouldn't be scared of getting involved after the sentence has been passed and saying to the judge, because you might sit there and think, oh, you've got that wrong. And I think most judges would welcome you addressing them on it there and then and saying, I'm sorry, Your Honour, but whilst they don't disagree with the conclusions that Your Honour's come to, I do submit that those decisions have been taken in the wrong order. And were they to be taken in the correct order, then it might result in a different outcome. Or indeed making that part of your submissions. You know, judges are always on the lookout for help from advocates. As advocates, we shouldn't be shy in giving them that help. You know, when it comes to racially aggravated offences or any offences that are aggravated, that the judges, Court of Appeal and the guidelines say, look, you should take the sentence for the simple offence and then increase it for the racial aggravation or whatever else there is. Judges welcome that sort of guidance. You know, there's no point in going to the Court of Appeal and complaining about it afterwards if you didn't give the judge the help at the time.
Just looking at these show notes, I've done a case summary in which it was set out by the Court of Appeal that you do your percentage reductions first, and then you do your reduction in sentence by way of credit as the final part. And it's Regina and RB, JS and HG. Regina and RB, JS and HG. I know I wrote it myself, but a very interesting case summary setting out how you approach it. So what are we saying, Clive, then? What are we saying in summing this all up? Is there a positive benefit to everyone to incentivize people to enter early guilty pleas? It's got to be, hasn't there?
Yeah. I think on the face of it, I think we often think of credit as something that's relatively straightforward. And, you know, plead at the start, get a third, PTPH 25% or a little bit later, and then the day of trial 10%. But there is a lot of nuance when it comes to credit. There is a lot of detail, such as what you put on the better case management form, what you say in interview, when you indicate your willingness to plead guilty to something. As I said, you know, the difference between 25% and 10% can be huge. reducing the starting point, not as a result of credit, but a result of other things that your client's done. It might be a burglary, for example, Colin. They might go into interview and say, yeah, do you know what? I stole that 91-year-old lady's engagement ring and wedding ring, and I pawned it at the shop on the high street. If you go down there and you took it there yesterday, you'll go and get it. And if the police were to recover that kind of evidence, that's hugely significant, isn't it? To say to the judge, come on, reduce the starting point. Send the message that if you break into people's houses and steal things of huge sentimental value and potentially huge value in and of themselves, if you tell us where they are, do you know what? We'll reward you for that. That's a message to go around the prison wings and landings, isn't it?
Isn't there also something to be said? We know the system's in a bit of a state at the moment. Isn't there something to be said for possibly reviewing a lot of those cases that have been set down for trials a long time ahead and saying, well, is there any possibility of putting those into a special court whereby they crack? Let's consider what sort of credit we're going to give to those people who crack their trials, No rigidity about it, each case to be considered on its own merits.
And I think speaking to those who are at the coalface, Colin, judges are being as flexible as they can within the rules. They are really stretching the rules as far as, and probably even beyond breaking point in the current climate. And I understand why. It's not a criticism, it's an observation.
Yes. Yeah. Let's sort out the legal aid position. Let's perhaps give the person at the police station stage something to work on. I don't know. That might be a consideration. But in the system we've got, because it's creaking, we've got to incentivize early guilty pleas at the same time as achieving the right balance, whereby clients are not incentivized to enter guilty pleas to things they clearly didn't do. Yeah. Because, of course, they would otherwise fear custody. That's why advising clients is so difficult.
There we are, Colin. On that happy note.
Yes.
We haven't decided on our September topic yet, have we? But as soon as we know, we'll let our listeners know too. But
yes,
as ever, thank you for tuning in. We hope you found it helpful and hope to see you next time.
So thank you. Thank you on behalf of myself. Thank you on behalf of Clive for watching this particular podcast. And we look forward to your company again on the podcast next month, whatever that podcast is going to be. I think we ought to call it, under no circumstances should you consider a timely guilty plea. How about that? Hey, and we'll give entirely the opposite views.
There we go.
Gotta go. Bye. Well, thank you for tuning in to this particular edition of the Legal Eagle podcast. We do hope that you've enjoyed it. You can find further episodes on our website, legal-eagle-training.com. On behalf of myself and Clive, thank you. Say goodbye, Clive.
Goodbye, Clive.